Welcome to the debate. Imagine you are pulled over for missing a turn signal, a minor annoyance, right?
Yeah, usually you just expect a quick warning.
Exactly. You expect to hand over your license, maybe get a ticket, and be on your way. But 51 minutes later, you are locked out of your car, separated from your passenger, and facing felony drug charges.
Which is a massive escalation.
It really is. At what exact second does a routine mechanical traffic ticket transform into an unconstitutional imprisonment?
It is a phenomenal question, and it really gets to the heart of what happens when the predictable script of a traffic stop collides with the unpredictable reality of human behavior. Because sometimes, a missing turn signal is just a missing turn signal.
Right.
And sometimes it is the thread that unravels a major narcotics operation.
Today, we are examining the constitutional boundaries of law enforcement authority during a traffic stop. We are specifically analyzing the dash cam and body cam transcript of Trooper Eichenlaub's stop alongside the pretrial motion and discovery documents in Commonwealth v. Ernest Paul Coit.
Right, so we are looking at a situation where a vehicle was pulled over for failing to use a turn signal and crossing a white fog line. A very simple start that ultimately resulted in a massive delay, vehicle searches, and significant legal consequences.
So the central question we must ask is this. Did the officer's actions, specifically prolonging the stop for 51 minutes before even starting field sobriety tests, and then conducting subsequent searches despite the passenger presenting a valid medical marijuana card, did that constitute an illegal fishing expedition under the Fourth Amendment and Pennsylvania state law?
Or was this a lawful investigative detention supported by the evolving totality of the circumstances?
And this debate emerges directly from the provided video transcript, the legal discovery documents, and several landmark court decisions. I will argue that this stop blatantly violated the timeline established in the Supreme Court case Rodriguez v. United States, as well as Pennsylvania's strict privacy protections. I believe the officer unlawfully extended the stop, making all subsequent evidence legally tainted.
And I will argue that the driver's physical demeanor, her admitted criminal history, and the wildly conflicting stories the occupants provided, all of that gave the officer independent reasonable suspicion to lawfully extend the stop.
Let's actually look at the timeline in the discovery documents set up my perspective here. The, quote, mission of this traffic stop was incredibly simple: a turn signal and white line violation. If we look at the video timestamp, the stop initiates at minute 4:43, but the officer does not request field sobriety testing until minute 49:10.
That is a significant gap. Absolutely.
I mean, it is a nearly 51-minute delay. Under the Supreme Court's ruling in Rodriguez, an officer cannot abandon the primary mission of a traffic stop, which is writing the ticket, to conduct an unrelated interrogation without independent, reasonable suspicion.
Well, they need that independent suspicion, yes.
Right. Furthermore, we have a glaring issue with the physical evidence on the scene. At minute 102.02, the passenger presented a valid medical marijuana card in its original packaging. Under Pennsylvania precedent, like Commonwealth v. Hicks, a legally licensed item is constitutionally neutral.
Okay, but
It cannot be used as an excuse to extend a seizure. Because this stop was unlawfully prolonged into a custodial detention, I argue the passenger has standing to suppress any evidence found as the fruit of a poisonous tree.
I understand the strict timeline you are presenting, but my perspective acknowledges that the Rodriguez standard does not operate in a vacuum. Reasonable suspicion is not a photograph. It is a film. It evolves dynamically.
Okay, how so?
Well, if we look at that exact same transcript, the officer almost immediately observes severe physical indicators of impairment, specifically extreme dry mouth and visible shaking.
People get nervous, though.
True, but then the driver openly admits to a history of manufacturing methamphetamines. She admits she has a parole officer who is just at her house due to a domestic violence incident, and she provides highly inconsistent stories. She claims she dropped a friend off at a bar called the Old Corner, but the passenger, a man she only knows as E, contradicts this entirely.
Right.
So these factors collectively and undeniably bridge the gap from a simple traffic infraction to a lawful, legally justified investigation for DUI and drugs.
Well, let's dive right into that 51-minute gap, because that is our first major point of contention: the actual mission of the stop and the sheer duration of this delay. The timeline is grounded in the discovery documents, right? The stop initiates at 4:43. The officer walks up and explains the reason for the stop: failure to use a turn signal when merging onto the highway from Lock Haven.
Yeah.
That is the mission.
Write a ticket for the turn signal. Yet instead of processing a citation, the officer engages in this sprawling interrogation about travel itineraries and passenger identities.
But asking about travel itineraries is standard operating procedure.
Asking where someone is going is standard, sure, but detaining them on the side of the road for nearly an hour before starting standard field sobriety testing, that is 45 to 51 minutes of investigative limbo.
It's a long time, yes, but
Think of a traffic stop as a timer. The moment the officer finishes the tasks related to the traffic warning, or the moment they frankly should have finished them, that timer hits 0. The stop is legally dead. You cannot artificially restart the clock just to go fishing for unrelated crimes. How can one possibly justify spending nearly an hour interrogating a driver about her passenger's last name when the initial infraction was just a turn signal?
I come at it from a different way, because your timer analogy assumes the officer is forced to ignore everything else happening right in front of him. But under Fourth Amendment jurisprudence, that Rodriguez clock pauses or entirely resets when new articulable suspicion arises. You mentioned the 45 to 51-minute gap. Let us explain exactly why that gap exists.
Please do, because 51 minutes is a lifetime on the side of a highway.
It is. But let's look at the mechanics of what the officer actually has to do here. He approaches the vehicle and begins the ordinary, legally permitted inquiries incident to a traffic stop. License, registration, destination.
Right, the basics.
Exactly. But during those permitted inquiries, the driver exhibits extreme nervousness and severe dry mouth. The officer asks about prior arrests, which he is allowed to do for his own safety and situational awareness, and she admits to a 2018 arrest for manufacturing methamphetamines. At that exact moment, the mission fundamentally shifted.
Shifted how?
It shifted from a minor traffic ticket to a potential DUI and narcotics investigation.
But does an admission to a past crime justify a present detention? I mean, 2018 was years ago.
Combined with the physical symptoms, yes, and untangling a narcotics investigation inherently takes longer. You have to separate the driver and the passenger to compare their stories.
Okay.
The driver says she dropped a friend off at the old corner. The officer then has to walk back to the passenger, ask him the same question, and realize the passenger is saying, quote, "No, we came down together to get a drink and she stayed in the car." Getting to the bottom of that web of lies takes time. It is not an unconstitutional delay. It is the reality of thorough police work.
That's an interesting point, though. I would frame it differently. The Supreme Court in Rodriguez was explicitly clear. An officer who completes all traffic-related tasks expeditiously does not earn extra time to pursue unrelated criminal investigations.
But it wasn't unrelated anymore.
Well, asking a driver about a 2018 arrest, an event that occurred years prior, has zero connection to ensuring vehicles are operated safely on the road today. It is the definition of a fishing expedition. In the transcript, the officer actually states, "I want to make sure there's nothing illegal inside your vehicle."
Right.
That is an outright admission of exploring for general crime, which Rodriguez strictly prohibits without concrete, independent, reasonable suspicion.
But he had independent, reasonable suspicion.
Did he? We have to be very careful about leaning on nervousness and dry mouth as the foundation for reasonable suspicion. As Pennsylvania courts have repeatedly ruled, nervous behavior alone does not provide a sufficient basis to warrant an investigatory detention.
True, alone.
Most people are nervous when pulled over by the police on a busy highway. And having a dry mouth, that could be from drinking too much coffee or the heater being on or, simply being anxious.
But it wasn't nervousness alone. That is the crucial distinction here. The law looks at the totality of the circumstances. It was the dry mouth, combined with the admitted meth history, combined with the fact that she is driving a man she claims to have known for 3 months, yet she only knows his name as the letter E.
Right, but
If you are a trained narcotics officer, those factors combined scream that criminal activity is afoot. The law allows an officer to cross over into a Terry stop, which is a brief legal detention where an officer can ask questions to confirm or dispel their suspicions.
even if we assume for a moment that her nervousness and the confusing stories justified that 51-minute delay, that brings up a glaring issue with how the officer handled the physical evidence on the scene. And this transitions us perfectly to the legal neutrality of the medical marijuana and a very troubling discrepancy in the audio transcript.
Ah, you're referring to the search of the passenger's bag.
Exactly. Let's look at the timestamps again. During the stop, the passenger explicitly presents a valid medical marijuana card in its original packaging at timestamp 102.02. He admits to having a vape. Now, let's explain the mechanism of the law here.
Okay.
Under the Pennsylvania Supreme Court's ruling in landmark cases like Commonwealth v. Hicks, which dealt with legally concealed firearms, and Commonwealth v. Barr, which dealt with medical marijuana, a legally licensed item cannot be treated as a clue to a crime. It is constitutionally neutral.
Meaning you can't use someone's lawful behavior to build reasonable suspicion.
Precisely. If I have a prescription for allergy medication, holding that bottle doesn't give a cop the right to search my car for illegal drugs. A legally licensed item cannot be a pretext to extend a seizure. But what is even more troubling here is a direct discrepancy regarding the officer's credibility and the public record.
The mic issue.
Right. At timestamp 43.05, the audio transcript mysteriously ends. The officer states he is putting the passenger's bag back in the car for, quote, administrative purposes, and then he actively suppresses the microphone.
You're saying he intentionally turned it off?
I am looking directly at the discovery document and video timestamp. Why suppress the public record right in the middle of a highly contested Fourth Amendment search inquiry when you combine an hour-long detention, ignoring a valid medical marijuana card, and turning off the mic for administrative purposes? It paints a picture of an officer acting completely outside the bounds of constitutional law to force a search.
I'm sorry, but I just don't buy that. Let me tell you why. First, regarding the mic suppression at 4305, you are making it sound like a conspiracy, but we are talking about a highly dynamic, potentially dangerous scene on the shoulder of a highway with two uncooperative individuals whose stories were not matching up.
But why turn off the audio?
The administrative purposes statement could very easily refer to securing the property before arranging a tow. In the transcript, the officer explicitly mentions they are likely going to tow the vehicle and apply for a search warrant because the driver refused consent. Turning off the mic to make logistical phone calls to a tow company or a supervisor is standard.
But shutting off the body cam audio during an active investigation deprives the defense and the courts of the objective truth of what was said during those crucial minutes.
Well, let's focus on the Hicks and Barr argument because I think that is the stronger legal question here. Yes, the passenger's medical marijuana card legally neutralizes the possession of that specific vape, but Hicks and Barr do not require law enforcement to wear blinders to the rest of the scene.
How so?
The medical marijuana card explains the passenger's vape. It does not explain the driver's extreme nervousness. It does not explain why the driver claims she brought a different friend down to Lock Haven and then literally choked up and admitted she lied.
Right. The card covers the marijuana. It doesn't immunize the entire vehicle from a search if the totality of the circumstances still points to drug trafficking.
I see why you think the totality of the circumstances justified the shift, but let me give you a different perspective based on Pennsylvania's specific constitutional framework, because you are still using the passenger's legal behavior to validate the continued detention of the driver. Let's look at why the driver was nervous.
Okay, when the officer asks her why she is shaking, she repeatedly explains she just went through a severe domestic violence situation. She explains that her parole officer was just at her house investigating it and that she is deeply intimidated by men towering over her. She provides a highly logical, non-criminal explanation for her demeanor.
But an officer isn't required to just take a suspect's word for it when other evidence contradicts them.
True, but let's explain how Pennsylvania law views this. Under Article I, Section 8 of the Pennsylvania Constitution, privacy is guarded much more fiercely than under the federal Fourth Amendment. The federal Fourth Amendment essentially says, you can search a car if you have probable cause. They call it the automobile exception.
Right.
But Pennsylvania treats your car much more like your living room. The mechanism here is a strict default rule. Go get a warrant unless there is an absolute immediate emergency. The officer cannot use a generalized hunch or a legally neutral medical marijuana card to pressure consent or extend the stop indefinitely.
But the officer did state he was going to get a warrant. He recognized that exact threshold. He told her, I'm going to tow your vehicle and I'm going to apply for a search warrant. He didn't just rip the car apart on the shoulder of the highway based on a hunch.
But he held them there.
He assessed the extreme inconsistencies. The driver saying they dropped a friend off at the old corner and the passenger saying they came down together. Under the law, an officer is legally permitted to freeze the scene to maintain the status quo while applying for that warrant. That is exactly how the system is supposed to work, when reasonable suspicion elevates to probable cause.
But to freeze a scene, you have to seize the people. And that brings us to the final and perhaps most fatal flaw in the Commonwealth's case, the issue of passenger standing and the fruit of the poisonous tree doctrine.
Ah, the Chavez argument.
Tension.
They point out that the officer removed the driver against her will, separated the occupants, and explicitly told the driver she was not allowed to return to her vehicle because she was, quote, being detained.
Right.
When a traffic stop exceeds the boundaries of a brief Terry stop and becomes a de facto arrest without probable cause, it is an illegal seizure.
And how does that affect the passenger?
This brings in the fruit of the poisonous tree doctrine. And for anyone not living and breathing constitutional law, think of it like a polluted river. If the source of the water, in this case the initial 51-minute detention, is toxic and unconstitutional, every single piece of evidence flowing downstream from it is also poisoned and cannot be used in court.
So the passenger is shielded by the driver's detention.
Under Chavez, because the driver was subjected to an unconstitutional custodial detention, the passenger was also illegally seized. Therefore, the passenger does not even need to prove they had a privacy interest in the vehicle. The foundational illegality taints everything, meaning all evidence found in the passenger's bag must be suppressed.
That's a compelling argument, but have you considered the legal distinction between a full custodial detention and a prolonged but lawful Terry stop?
I think 51 minutes blurs that line beyond recognition.
Well, you are relying on the defense's pretrial motion, which naturally frames the detention as custodial to get the evidence thrown out. But look at the actual mechanics of the encounter. Under Pennsylvania law, officers are explicitly permitted to control the movement of a traffic encounter for safety and investigative purposes.
Right. For safety.
Yes, and when the officer tells the driver she cannot get back in the vehicle, he is securing the scene. He literally says, "I'm not going to let you get back in your car at this time because you're detained. You're not being honest with me."
But detained for 51 minutes feels like an arrest.
A Terry stop inherently involves an official compulsion to stop and respond. It does not automatically equal a formal arrest. The Supreme Court established years ago that the intrusion of making someone stand outside a vehicle is incredibly minor, de minimis, compared to the vital interest of officer safety.
But for almost an hour?
You have two people telling drastically different stories, one admitting to a meth history. The detention was prolonged, yes, but it was legally justified by that escalating web of lies. It wasn't a toxic river, it was a lawful investigation following the evidence where it led.
I have to disagree on the safety aspect. There is a massive difference between asking someone to step out of the car for safety and holding them on the side of the highway for 51 minutes while you interrogate them about their passenger's last name. The Supreme Court in Rodriguez specifically addressed this exact loophole.
How so?
They ruled that safety precautions taken to facilitate detours from the mission do not pass constitutional muster. The officer wasn't securing the driver so he could safely write a turn signal ticket. He was securing her to facilitate a wholly unrelated drug investigation.
Because the drug investigation became the new mission.
But we must return to the causal link analysis of the poisonous tree. But for the officer illegally extending the stop past the time it takes to write a turn signal warning, the police would never have been in a position to search the passenger or his bag. The exploitation of that initial 51-minute delay is exactly what produced the evidence.
Well,
And under Pennsylvania's strict exclusionary rule, which exists specifically to safeguard our individual privacy rights, not just to punish bad cops, that evidence must be barred from the courtroom.
And I maintain that the causal link was not broken by an illegality because the extension of the stop was not illegal in the first place. The Rodriguez timer, the point where tasks tied to the traffic stop are completed or reasonably should have been, was legally paused at the exact moment the driver exhibited severe indicators of impairment and admitted to a meth history.
I just don't see it that way.
You cannot expect a police officer to simply hand a ticket to a driver who is shaking, suffering from severe dry mouth, and giving nonsensical travel stories and just wave them back onto the highway. That would be a massive dereliction of duty regarding public roadway safety.
Well, we have unpacked a tremendous amount of constitutional mechanics today, and it's a dense topic. To summarize my position, I believe this 51-minute traffic stop represents a textbook violation of the Rodriguez timer. A minor traffic infraction cannot be used as a gateway for an hour-long fishing expedition. Furthermore, we must protect the substantive bar set by cases like Hicks and Barr. Lawful behavior, like holding a valid medical marijuana card, must be respected as legally neutral under Pennsylvania's strict privacy framework. It cannot be used as a backdoor to a search. When officers suppress their microphones and turn minor stops into unconstitutional detentions, the Shabazz doctrine ensures that the resulting tainted evidence is thrown out.
And to summarize my view, the officer's actions here were a textbook example of following evolving reasonable suspicion. The Rodriguez standard is not a stopwatch that forces officers to ignore reality.
Right.
The combination of severe physical indicators, an admitted criminal history of manufacturing narcotics, and blatant, irreconcilable inconsistencies in the occupant's stories fully justified the prolonged investigation. The officer didn't act on a mere hunch. He acted on a compounding series of behavioral red flags that legally bridged the gap from a simple traffic ticket to a valid narcotics detention.
It is clear we will continue to disagree on the exact minute or even second when this routine stop crossed the line from a lawful Terry extension into an illegal seizure.
We will, but it truly reflects the immense value of examining these complex, real-world interactions through the lens of constitutional law. The tension between a law enforcement officer's duty to investigate the totality of the circumstances and an individual's constitutional right to privacy remains one of the most vital, shifting areas of modern jurisprudence.
Absolutely. I highly suggest that our listeners look further into the source material, the dashcam transcripts, the discovery documents we discussed today, and the Rodriguez and Shabazz frameworks to explore these nuances for themselves.
The line between a lawful investigation and an unconstitutional detention is almost always drawn in the margins of these exact types of encounters. It is never as simple as it looks on paper.
Indeed. It brings us right back to that initial thought. We all want the transaction of a traffic stop to be simple, clean, and fast. But when the questions start and the timer keeps ticking, we have to rely on the Constitution to determine if the state has gone too far or if they're simply doing exactly what society asks them to do to keep the roads safe. Until next time.